Be ready for the dictation. Start. We have recorded reasons for condoning the delay in the main judgment. The first respondent filed a writ petition under Article 226 of the Constitution of India before the High Court of Delhi for questioning the acquisition of the land's subject matter of the writ petition. The acquisition was under the provisions of the Land Acquisition Act, 1894. The notification under subsection 1 of Section 4 of the 1894 Act was issued on 23 June 1989, which culminated in an award under Section 11 of the 1894 Act, which was made on 18 June 1992. In the meanwhile, in the year 1990, the first respondent filed a writ petition challenging the acquisition proceedings, which was dismissed on 20 May 2005. On 19 January 2006, the appellant took over possession of the acquired land. With effect from 1 January 2014, the 1894 Act was repealed and the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013 were brought into force. On 25 May 2015, the first respondent filed a writ petition contending that in view of subsection 2 of Section 24 of the 2013 Act, the acquisition shall be deemed to have lapsed. By the impugned judgment and order dated 11 August 2016, by relying upon a decision of this court in the case of Pune Municipal Corporation and another versus Ramesh Solanki, the High Court held that subsection 2 of Section 24 of the 2013 Act will apply as the compensation has not been paid to the first respondent although physical possession of the acquired land has been taken over by the appellant. The High Court, however, directed the appellant to pay compensation to the first respondent in accordance with the 2013 Act. On 6 March 2020, a constitution bench of this court in the case of Indore Development Authority v. Manohar Lal and others to expressly overruled its earlier decision in the case of Pune Municipal Corporation and UNR.1 and all other decisions based on the said decision. It was held by the Constitution Bench that another decision of this court in the case of Sri Balaji Nagar Residential Association versus State of Tamil Nadu and others was not correct. Even this decision was relied upon in the impugned judgment. The Constitution Bench in the case of Indore Development Authority to interpreted subsection 2 of Section 24 of the 2013 Act. Subsection 2 of Section 24 of the 2013 Act reads thus. Notwithstanding anything contained in subsection 1, in case of land acquisition proceedings initiated under the Land Acquisition Act, 1894, where an award under the said Section 11 has been made 5 years or more prior to the commencement of this Act but the physical possession of the land has not been taken or the compensation has not been paid, the said proceedings shall be deemed to have lapsed and the appropriate government, if it so chooses, shall initiate the proceedings of such land acquisition afresh in accordance with the provisions of this Act. Provided that where an award has been made and compensation in respect of a majority of land holdings has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notification for acquisition under Section 4 of the said Land Acquisition Act shall be entitled to compensation in accordance with the provisions of this Act.